Welcome to Canadian Justice. I'm Christine Van Gyn, and today we're talking about life sentences, parole eligibility, and a recent case from the Supreme Court of Canada. On January 29th, 2017, 27-year-old Alexandre Bissonnette entered a Quebec City mosque and opened fire with a gun. It was one of the worst mass shootings in Canadian history. Bissonnette killed 6 and seriously injured 5 more. Bissonnette pled guilty, and the Crown asked for all the murder sentences to be served consecutively, making him ineligible for parole for 150 years. In 2011, the Harper government introduced sentencing provisions that gave judges the discretion to order parole ineligibility for multiple murders to be served consecutively. Is that law excessive? On one hand, it seems unfair that someone who would get a discount on murder, but on the other hand, if the sentences and parole eligibility are imposed back to back, parole eligibility would exceed the human lifespan. The lower court sentenced Bissonnette to 40 years in prison without parole, finding that his crime deserved more than 25-year parole ineligibility, but that ineligibility for more than 40 years would be disproportionate, cruel, and unusual. The Court of Appeal then reduced his eligibility for parole to 25 years. And now the Supreme Court of Canada has ruled that the stacking of parole ineligibility is unconstitutional. Here today to discuss the decision are 2 legal experts, Professor David Millward and criminal defense lawyer Sarah Lehman. Thank you both so much for joining me today. Sarah, let's start right off the bat with what the Supreme Court held. Can the sentences and parole ineligibility periods be stacked?
Sure. Now, what really strikes me about this decision is that it was a unanimous one from the court. So it's a very strong decision. And what the court said was that parole ineligibility periods cannot be stacked. The reason for that is because of Section 12 of the Charter. Of course, that section of the Charter protects Canadians from cruel and unusual punishment. And the court was very clear in stating that a sentence that cannot be served, one that exceeds the normal life expectancy of a person, is cruel and unusual and cannot simply stand.
David, is there anything that you want to add to what the Supreme Court held in this case?
Yes, so the previous jurisprudence on Section 12, it focused on whether a sentence was inordinately long in proportion to a reasonable hypothetical situation that could come up with some frequency. We now see a new wrinkle with the Bissonnette decision that if a law results in denying someone any reasonable possibility of rehabilitation, even in cases where rehabilitation seems a weak possibility, that speaks to cruel and unusual punishment. And that was a major theme in the Bissonnette decision.
David, the way a lot of lawyers have characterized this case is that it's about the stacking of parole eligibility, not the stacking of sentences. But if you're eligible for parole after serving the first sentence, is that really a meaningful distinction here?
I understand what the lawyers are saying, but I don't really see it as a meaningful distinction, because when you stack life sentences together, the sentence itself is life imprisonment, and how long can you even wait before even applying for parole? So I think those parole and eligibility parole periods are integrally joined at the hip and linked together with the life imprisonment.
Sarah, same question. If the result is that a mass murderer like Bissonnette could get out of prison after parole for the first sentence, how is that different in practice from the sentences being served concurrently?
Yeah, I think that we're going to have to see how this plays out, of course. But the important thing to emphasize here is that the Supreme Court's decision applied to parole, not necessarily to sentences. So I think it will still be possible for our courts to hand down very harsh sentences in relation to more heinous or egregious crimes, but still have that person eligible to at least apply for parole, not necessarily have it granted.
So this case was really about Section 12 of the Charter, which is cruel and unusual punishment. David, we're up against a commercial break, about 20 seconds. Anything that you can explain what that term means to non-lawyers?
Either the sentence is too long, which means grossly disproportionate, or sometimes there's just a punishment that's just out there that offends any sense of decency, like execution or judicial corporal punishment, like lashing.
Okay, I understand. So it would be in the first bucket, not the second here. We've got to go to commercial break here, but we will be right back to continue this conversation. Welcome back to Canadian Justice, where we are discussing a recent decision from the Supreme Court of Canada in the Bissonnette case about the stacking of parole eligibility periods and whether life in prison for multiple sentences really, if you can get out after you've served the first of those sentences. So, Sarah, one of the concerns that I have seen raised by victims groups is that when parole eligibility for the first sentence comes up, the victims' families attend those hearings. They make arguments against granting parole. And now this creates a burden on the families to relive the trauma and the grief of the murder of their loved ones and face that killer at these hearings. So if parole eligibility was stacked, that wouldn't be necessary. Do you have anything to say about that?
Sure. I mean, of course, there's always concerns about the re-victimization of victims. And in this case, a family member would be considered to be a victim where the person is deceased and not able to advocate for themselves. That being said, any victim's participation in the parole board process is voluntary. They have a right to the information, they have a right to attend, they have a right to make a statement in whichever medium they choose to do it in. But again, it is voluntary. And so I think it's important for people to keep that in mind and to also consider maybe where their boundaries or comfort zone lies if they are considering, say, adding themselves to a victim list if they're eligible to do so.
David, is there anything you want to add to that?
Yeah, I would say that part of it is that the judgment itself seems to downplay that perhaps there's value in making a normative condemnation of particularly heinous, hate-filled or murder sprees, such
Which
as we see.
this was one, right? This was a racially motivated, religiously motivated mass murder at a mosque.
Yeah. So that's the other part for concern for the victims is why not just have that normative condemnation and spare us the trouble of having to apply to keep someone in there. I can see that concern, yes.
David, parole eligibility, though, still means eligibility, right? Life can still mean life. Just because someone's eligible for parole at 25 years doesn't mean they'll get it. It could be denied, for example, if the convicted person is a dangerous offender. What's taken into account when someone is considered for parole? What could it take for it to be granted or denied?
Okay, so there is a provisions in the Corrections Conditional Release Act, and there's objectives, which include rehabilitation, reintegration, and all the rest of it. But that provision is also very clear that protecting the public from risk of harm is the key objective. So when someone actually does apply for parole, they really got to make a good sale that they're not going to be a risk if they're paroled. And I know the parole board sometimes gets flack for letting someone out that the public thinks they shouldn't have released. But my own observation is that in the great volume of cases, it can be a really hard sell. The parole board really has to be satisfied that there's next to no risk before granting parole.
Sarah, same question. Anything to add there? For example, what do you think the likelihood is that a killer as notorious as Alexandre Bissonnette, whose crimes were so egregious and hate-fueled, what's the likelihood of a person like that receiving parole after 25 years?
Yeah, and I definitely echo David's sentiment there in that just because you're eligible to apply for parole, it doesn't mean that you're going to be granted parole. The parole board is able to take a huge volume of information and evidence into account when they're considering whether or not it's appropriate to grant parole. Of course, one of the paramount considerations is the person's risk of reoffending and the protection of the community, but they'll have a lot of information at their disposal. They will have the person's criminal background, any interaction with the court system they've had in the past, information from mental health workers, correctional authorities, victims' families. There's a lot of relevant considerations that go into this. It's certainly not a flippant decision.
Yeah, certainly. And there are a lot of notorious killers in Canada. I think people, their mind would probably jump to someone like Paul Bernardo, for example, who's deemed a dangerous offender, has not been eligible for parole. So it's entirely possible that while Mr. Bissonnette could be eligible for parole at 25 years, that he may not, in fact, be granted it. But as you've all laid out, that is up to the parole hearing, something that the families may be participating in. Welcome to Canadian Justice, where we're discussing the case of Alexandre Bissonnette and whether life sentences and parole eligibility can be stacked or served consecutively in order, or if it can be served concurrently. Now, Professor Millward, how many people have been given these consecutive life sentences with stacked parole ineligibility periods since the law was changed in 2011? And what's going to happen to those people now that the law has been struck down? Will their sentences be amended?
So by my count, there's been at least a dozen cases where this provision or this decision could apply retroactively. And these include some cases that are just as notorious as Bissonnette, like Alex Manassian, who ran over women on Yonge Street, or Justin Bork, who targeted police officers during his murder spree. So the controversy isn't going to just stop at Bissonnette. It's going to potentially apply to some very notorious other cases. And with this law being struck down, I can see these people applying to have their stacked periods revoked.
Well, it certainly will be controversial if that happens. Sarah, anything to add on that?
Yeah, I mean, again, as David's highlighted, I think it's important to keep in mind that it is a process of applying. I'm not so certain that it will just automatically apply in a retroactive fashion, but rather it's more likely that it'll be up to the individual incarcerated person to make that application.
So, Sarah, one of the things that the case has really brought up is a debate around the purpose of sentencing. Is the purpose to rehabilitate criminals, in which case a sentence longer than a human lifespan does not achieve that goal. It cannot rehabilitate you if you will never get out. Is a long sentence about deterrence? Is it about punishment and the recognition of the particularly heinous nature of some of these crimes? What can you say about that?
Yeah, well, all of those things are important cornerstones of our justice system. So rehabilitation is in some ways just as important as denunciation and deterrence. But what the Supreme Court of Canada said here, and I tend to agree with them, is that those principles, including the principles of denunciation and deterrence, are not properly served when you have a sentence that's just completely incompatible with reality, and that's unrealistic. And so in order to properly serve those types of principles, we have to have a sentence that makes sense.
David, anything to add there on your views of the purpose of sentencing?
I do understand that perspective, and I'm not necessarily disagreeing with it, but I'm just going to offer the contrary perspective of how the public might view this. During the judgment itself, the court does briefly acknowledge denunciation as a separate objective in its own right, but then for the rest of the judgment, they do deterrence and denunciation together several times, but they're actually distinct objectives. So even if deterrence is not a realistic possibility in this case, there is something, for some people, there is something to be said for making this strong normative condemnation through stacked sentences for the most heinous types of crimes. And again, not just Bissonnette, but for example, if Manassian ends up applying for revoking his stacked sentences, does that devalue the lives of women who are round over on Yonge Street, or the police officers that were murdered by Justin Bork?
Important observations. Now, David, one of the things that the Supreme Court has emphasized in this case was the psychological effect on Bissonnette himself of stacking the sentences and parole eligibility. that giving a convicted person a sentence without any opportunity for release gives them no incentive to improve themselves. So, what can you say about the psychological effect here and why the court considered it to be so important?
It goes hand in hand also with a lot of arguments made about solitary confinement. When you just give this person absolutely no hope, there's some real profound health effects on that person. And so, I do agree for these individuals, if there's no hope, absolutely there's going to be some sort of response within. Now, not taking sides here, but the counter argument that some people might make is the more heinous of this type of crime that you occur, the more that your own liberty interests are forfeited.
Sarah, we've only got about 30 seconds left, but the Quebec Court of Appeal used really forceful language in their decision that reduced his sentence. They called the long sentence absurd, evil, degrading, a vengeful spirit that had no place in a civilized sentencing system. What can you say about that language?
Well, it is certainly strong language, and I think it's jarring to see that when we consider the nature of the crime that they were considering. But at the same time, Supreme Court of Canada kind of echoed the same sentiments, just in more restrained language.
We've got to go to commercial break, but when we come back, we will discuss more about the details of this case. Welcome back to Canadian Justice, where we're discussing the case of mass murderer Alexandre Bissonnette and whether his life sentences and parole ineligibility periods can be stacked. Now, Mr. Millward, Professor Millward, one of the things that's interesting here is this interaction between the legislature and the courts. So the legislature, under the Harper government, decided they wanted to punish some especially horrific crimes, mass murder, more severely and treat Canada's serial killers in sort of a different category. But here we have the courts essentially saying, no, you can't do that. So what can you say about that?
The previously the cruel and unusual punishment provision in the charter, beforehand it was used as a kind of pushback against mandatory minimums. That's the main way in which Section 12 had been used. Now we see the court using it in an even more stronger way, where they're emphasizing the prospect of reasonable rehabilitation and adding a new gloss to grossly disproportionate. I think the court could be understood where it's coming from when it wanted to push back against the mandatory minimums. But now striking against this particular law, I can see some people perhaps wondering whether the court now is becoming too activist, acting against a law that perhaps had significant political and popular support.
Yeah, I mean, I certainly think Canadians, I think, would be fine with life without parole at all. The average Canadian for a mass murderer, but obviously we're not governed by public opinion polls. Sarah, anything to add on that?
Yeah, I have to say that I do have a real issue with the government kind of responding to decisions of the courts that are unpopular, or that there's some pushback from the public in relation to in these knee-jerk manners. And it's not the first time we've seen politicians, saying or actually passing legislation in response to unpopular Supreme Court decisions. So I do think that is somewhat problematic. But again, that's just my own personal opinion on that.
Now, Sarah, that's an interesting point, because there has been talk among a group of politicians in the Conservative Party in particular about a legislative response to this. There are a number of Conservative leadership candidates who have said that they would invoke the notwithstanding clause, Section 33, to reenact this legislation. To override the Section 12 rights of convicted mass murderers and reintroduce this law to allow for stacked eligibility periods. Do you have any thoughts on that?
Yeah, I mean, I think it is alarming, to say the least. The notwithstanding clause should be used very sparingly, if at all. I think that just, throwing it around and reducing it to something that we say we're going to use or we actually do use in response to unpopular court decisions really undermines the authority of the judicial process and ultimately of our courts.
David, anything to add there on the potential use of Section 33 to reintroduce this legislation federally? And correct me if I'm wrong, but I don't think Section 33 has ever been used federally.
No, it
No.
hasn't.
Just by the Quebec government for language laws.
I think it's been
So-
used in Saskatchewan, and it's been used in Ontario now for some election laws. But I mean, is this something that you think is a realistic option, that the federal government might use this?
Well, there's two sides to the coin. So I do echo Sarah's comments that it should be used sparingly, because if you use it frequently, that starts to display, oh, we're the government, we're not bound by the constitutional restraints. And in fact, it actually is the court's job to render laws unconstitutional if they are, without concern for whether it will be popularly received or not on the constitutional merits. But again, at the same time, the other side of the coin, as I previously mentioned, is, of course, becoming a little too activist. Are they interfering with a popular mandate through its and represented by elected politicians?
Well, I want to thank you both for coming on today and walking through this complicated topic. It's certainly going to be a controversial one. We've heard today about the arguments about whether killers convicted of murdering multiple people should be sent to prison to serve life sentences back to back with stacked parole eligibility. These are difficult questions, and they go to the core of what we think the purpose of incarceration is. Do we send people to prison to punish them, to rehabilitate them, to give peace to their victims and their families, or to deter others? How you answer this question will likely impact how you answer the question of whether you think killers should be given consecutive life sentences with stacked parole eligibility. What do you think of the decision by the Supreme Court? You be the judge. I'm Christine, and remember, a freer Canada starts with you.